Welcome to The Explainer. Today, we're unpacking a highly charged, super emotional topic, infidelity, and how it actually intersects with Canadian family law. Look, it's a painful subject. I totally get that. But today, we're taking a step back. We're going to look past the heavy emotions to see exactly how the legal system operates under the hood. So, to kick things off, we recently got a message that perfectly captures the confusion around this whole topic. A viewer asked us, "My spouse cheated on me in Canada. How do I cut them out of the property division or stop them from getting spousal support?" And honestly, it's a completely raw, understandable question. When you've been betrayed, you'd naturally think the law would want to step in and penalize the wrongdoer, right? Well, the short and, honestly, pretty surprising answer is you generally can't. The reality is, infidelity has almost zero direct impact on these financial outcomes. Why? Because in Canadian family law, math wins over morals every single time. The law is looking purely at the money, not the morality of what happened. Okay, let's dive into this. First up, we're looking at the no-fault reality. So here's how it actually works. Canada has what we call a no-fault legal system for divorce. Basically, this means the courts simply do not care who's to blame for the breakup or who made a terrible ethical mistake. If you look at Section 15.2, subsection 6 of the Federal Divorce Act, judges are actually explicitly banned from considering marital misconduct or affairs when they're making support decisions. The wording here is intense. Saying the court shall not take into consideration leaves literally no room for a judge to punish a cheating spouse. Their hands are totally tied on this. Moving right along, let's talk about Pillar 1, spousal supports. So you're probably wondering, if the court isn't looking at who broke their vows, what exactly are they looking at? Well, instead of affairs, the court relies strictly on a set of objective factors. They want to know the length of the marriage. They look at the roles each spouse played. Like, did one person stay home to raise the kids while the other built up a lucrative career? And crucially, they look at the condition, means, and needs of each spouse. When you boil it all down, it's just three things: income, financial need, and the ability to pay. That's the math. Next up is Pillar 2, child support. Now, when it comes to child support, it gets even simpler. And that's because child support is the absolute non-negotiable legal right of the child. It has absolutely nothing to do with the parents' relationship with each other. The federal child support guidelines use a strict formula that is just based on income. Let's walk through this real quick using a specific math example for British Columbia. Say the parent paying support has an annual income of $51,250, and there are two kids. The table gives a basic amount of $807, plus a tiny percentage of the income over 51K, adding $3.85. So the math spits out a highly specific final monthly support obligation of $810.85. And this brilliantly illustrates the reality of the whole system. An affair between the parents doesn't change a child's right to financial support even a little bit. It doesn't subtract a dime from that $810.85, and it for sure doesn't add some kind of penalty fee to it either. A parent's affair changes absolutely nothing about this final, strict mathematical obligation. All right, let's shift gears to Pillar 3, dividing family property. So while the Federal Divorce Act handles things like support, it's actually the provincial laws in places like Ontario and BC that handle how you divide your property. To do this, we have to define exactly what is on the table. The law essentially throws things into two buckets. First, you have family property. This is the real estate, the joint bank accounts, the pensions that you acquired during the relationship. The baseline here is financial equity. The second bucket is excluded property. This includes stuff you already owned before the relationship started, or maybe an inheritance you got. The growth in value on excluded property is shared, but the base value, that's generally kept separate. But for all that family property that you built together during the marriage, provincial laws dictate that the presumption is a 50-50 split right down the middle. And again, I can't stress this enough. This equal split happens regardless of who caused the breakup or whose infidelity led to the divorce. Okay, but here's where things get wild. Let's look at the Trojan horse exception, financial misconduct. Now, what's really interesting here is that there actually is one major exception where a spouse's behavior finally matters to the court. I like to call it the Trojan horse exception. We have to clearly distinguish between a moral failure and financial misconduct. Look, the court doesn't care about the secret affair itself. That's just a moral failure to them. But they care deeply about the financial impact of that affair. If a spouse drained joint family bank accounts to buy expensive gifts for a new partner, or took out secret credit cards to fund hotel rooms, well, now that crosses the line into financial misconduct.
And when that happens, provincial courts, like the Supreme Court of British Columbia, are fully equipped to step in. They oversee the strict application of the Family Law Act, and they absolutely have the authority to address situations where one spouse acts in bad faith and actively damages the family's financial standing.
To put that into legal perspective, Section 95(2)(g) of the Family Law Act gives judges the power to act if a spouse intentionally depleted family wealth. If someone hid assets or intentionally drained the family bank accounts to fund their double life, the law treats it purely as asset depletion. So what does the court do? They'll actually adjust the math to make the innocent spouse whole, maybe by giving them a much larger share of the remaining assets. But remember the distinction here. They are adjusting the math to fix a financial wrong, not to punish a broken vow. So the absolute crucial takeaway is this. Canadian family law will always address the math of asset depletion, but it will never address the moral failure of infidelity. If the affair didn't cost the family money, it's not going to cost the cheating spouse anything extra in court. Math wins over morals.
Which brings us to our final section, strategic next steps.
So what do you actually do with all this information? Family law in Canada has a ton of hidden financial moving parts that can permanently affect your future. If you're navigating a separation, a divorce, or a complex property split right now, please don't let emotions dictate your legal strategy. Step 1, you have to remove the emotion from the equation. Step 2, review your financial situation completely objectively, keeping an eye out for any actual financial misconduct. And step 3, do not do this alone. Reach out to our team at Pax Law Corporation so we can review your financial situation and guide you through the process the right way. Seriously, send us a message today to book your consultation. I want to leave you with one final provocative question to think about. Are emotions dictating your legal strategy? If you're angry and hurt right now, that is entirely valid. But bringing that anger into a Canadian courtroom expecting financial vengeance, that's only going to result in major disappointment and some really high legal bills. Understand the math, protect your assets, and navigate your separation with absolute clarity. Thanks so much for joining me for this explainer, and we'll see you next time.